All right, so Darrell Brooks, the man who was helplessly abducted by a runaway SUV and forced to sit in horror in the driver's seat as it plowed into a parade full of children up in Waukesha, Wisconsin, is going to trial. And of course, I kid, this is a man many would call a monster who decided to drive his SUV into a packed Christmas parade in a town in Wisconsin, causing significant atrocity. He ran over and killed, I believe, 6 people, and he injured many, many more. He has just won a little bit of a victory, I guess, depending on your perspective, in his case, in that he has been granted the right, his right has been recognized to represent himself in court. He will act as his own attorney. He has fired his public defenders and said, I do not want them. I can do this job. Now, that comes with significant risks and pitfalls, which I'm going to get to. But first, let's talk about why he's able to do this. I mean, this is a multiple intentional homicide case, and he stands to potentially serve the rest of his life in prison without the possibility of parole. So why should he be allowed, he, a mere mortal, a layman, be allowed to represent himself when an attorney would presumably do a much better job? Well, it's this little thing called the Sixth Amendment and a bit of liberty that we all have. You see, the Sixth Amendment is where your right to competent counsel is recognized in the Constitution. Again, the Constitution does not grant us our rights. It recognizes rights that are inherent to us. And the Sixth Amendment is where we say, yeah, every person has a right to competent representation when the state is coming down on them with a criminal charge. Darrell Brooks is no exception. But the other side of that coin is the competent representation that you choose can be yourself. So while you can force the state to get an attorney for you if you cannot provide one on your own, if you want to act as your own attorney, the state cannot stop you as long as you are competent to do so. And competence does not mean skillful. Competence literally just means something along the lines of, can they understand what is going on in the courtroom, follow basic rules and schedules, and also speak and communicate intelligibly, not intelligently, intelligibly in English or through a translator, right? Like that's basically it. Can they communicate intelligibly, and do they understand what's going on around them? Because at all times during a criminal trial, criminals must be informed competently of their rights, or they must have a representative. I say criminals, the accused. Oh my goodness, let me catch myself. Or they must have a representative who can understand those rights and act in their interest. Mr. Brooks has been found by this court to have no reason that he is incompetent. His competency has never been raised in any judicial proceedings before, and he has the equivalent of a high school diploma through something like a GED. I'm not sure of his specific education, but that is typically about all it takes. Now, he also underwent 4 psychiatric evaluations, and they found that he did have some level of personality disorder, which may prove disruptive in court, and indeed he's had a couple outbursts so far, but that alone is not sufficient to remove representation. Ooh, the shadow. The shadow's looking nice. That alone is not sufficient to remove his ability to represent himself. Just being disruptive in court actually applies to any number of people who are competent. Even attorneys, in many cases, who are very competent, may be disruptive in court depending on the circumstances. So that is not enough to remove his ability to represent himself. But as I said before, this comes with significant pitfalls. It comes with some challenges for the state, but mostly they're pitfalls for Mr. Brooks. Mr. Brooks will be representing himself. That means he will be delivering opening arguments. Actually, it starts before that. He'll be doing the voir dire of potential jurors. He will have to come up with questions to ask the jurors that he finds sufficient to determine if those jurors should sit in judgment over him. He will also be responsible for levying any challenges to jurors. And that's a really complicated process. Jury selection typically involves someone with a level of skill or experience selecting this jury, knowing what questions might lead to uncovering some sort of bias that would cause this person to not be impartial. Mr. Brooks is going to do that on his own. He will not be allowed the assistance of some other attorney or any other representative. He has to do that. After that, he'll be delivering his opening arguments. He'll be examining and cross-examining witnesses that the state calls and that he calls to the stand. And finally, he will deliver his closing arguments. He has to follow all of the rules as well. So when he presents evidence, he has to present evidence that is admissible under the rules of civil procedure and the rules of evidence. He'll have to do all of that. Any motions he wants to file have to follow the rules of civil procedure in Wisconsin. And the real pitfall comes not so much with him presenting his own case, but with him challenging the case the state presents against him. That is where the issues tend to lie on these things, because you have to know when to object, to make valid objections, to acquire rulings on those objections, to file motions, to oppose motions filed against you, and really, in his case, probably to properly preserve the record for an appeal. It is extremely likely that Darrell Brooks will lose this case and go to prison for some length of time. It is extremely likely, in my opinion, that he will go to prison for the rest of his life without the possibility of parole. Now, it's possible that at some point the government would make a procedural error or mishap in this case that could lead to a reduced sentence, or even some sort of, I guess, technical acquittal, where the government oversteps, infringes on his rights, and then, of course, he would be able to challenge that as a violation of his due process. But you have to know what those things are. You have to raise the objections at the time, and you have to preserve those objections for the record so that that can happen on appeal. Someone who is not a skilled attorney with experience in these types of trials may have trouble doing just that. And that is the major pitfall for him. The major pitfall for the government in this case will be taking extra precautions to not overstep their bounds on someone who is not an attorney, because if there is some sort of evidence, we'll say, of gamesmanship or some sort of abuse of power by the state, then that could actually be seen as prejudicial to Mr. Brooks if he's not represented. Although he's not supposed to be held to a different standard, let's face it, when people represent themselves, they do get a little bit of different treatment. And it'll be up to the government to go ahead and stop that from happening on their end as much as possible. But ultimately, at the end of the day, he's the guy who has to challenge any of their impropriety, and that is a big risk for him. So, his trial starts on Monday, October 3rd. I hope to watch a bunch of it, if not all of it, and we'll see if those pitfalls prove fatal to his case. This is a man who stands accused of intentional homicide. That means the government has to prove that he intended to or reasonably should have known that his actions would lead to the death of these individuals. If they prove that, it becomes life in prison without the possibility of parole. Now, if they can't prove that specific intent to kill, it could be reduced to a vehicular homicide or something like that. We'll see how it goes. But I hope you'll watch with me, and I'll try and keep this updated as well. We'll see you soon. Peace. Peace.